Welcome to Mouth Closed Media. Today's episode we will be covering self-defense. Hit the like button and subscribe, it doesn't cost you a dime. Leave a comment if you don't believe in the self-defense laws.
As a former state prosecutor and defense attorney, I'm sometimes asked the question, what is actually considered a self-defense incident? Well, a self-defense incident is any time where if you're in court, your attorney's going to be raising something called the privilege of self-defense. Well, what's that? Very simply, it's not defense of stuff or things, it's defense of you, defense of yourself. To do so, you have to be in some form of threat. Now, if you use deadly force, then you have to have been under threat of deadly force.
That's victim 43-year-old Brian Freddy standing on a driveway on the edge of his brother-in-law's property. Coming out on the porch is his brother-in-law, Russell Woods, who's now 34. The victim is talking to someone off camera. Suddenly, he runs at his brother-in-law on the porch and pushes him. What happens next is deadly. The Lincoln County Prosecutor's Office alleges it's first-degree murder. A probable cause statement written by an assistant prosecutor says the brother-in-law is yelling something offensive, which leads to victim Freddie running at him. The prosecution also alleges that Woods was concealing his gun behind his back and that he also smiled before pulling it out and shooting.
I don't believe it shows self-defense.
It was Cheryl Bertle's son who died. She hopes the video will answer years of questions.
There are so many people who have different ideas about what went on.
Our client had no idea that his brother-in-law was coming over to his house. He protected himself and his 1-year-old child that was sleeping on the other side of the window.
So one of the biggest things is, again, you got to be in fear for your life or serious bodily injury, but also you don't keep shooting when a threat is stopped. If somebody breaks into my office right now and threatens me with a knife, and I have my trusty 1911 here, I'm not going to point it at the camera, and I shoot this guy right here, and he drops to the ground after I fire 2 rounds, well, guess what? That threat is stopped. Guy was bursting into my office with a knife, fired 2 rounds, he plops to the ground. He's not a threat anymore. I can call 911. Now, if he keeps coming at me, you better believe I'm going to empty this whole magazine and fire as many rounds as I want. Doesn't matter if it's 2 rounds, doesn't matter if it's 20 rounds, as long as I stop the threat. But as soon as that guy's on the ground, I can't walk up to him, see he's not moving, and pop, put 2 more rounds into him for good measure because I hate this guy who just tried to kill me. Cannot do that. Not a good thing because that threat is stopped.
Take a look at this video from the front porch. You can see the man kicking the front door on James Taylor Lane and screaming at those who are inside.
You want to play? Let's play.
Then the 54-year-old man goes back to kicking in the door. After a few tries, he gets in. The sheriff said once inside, he armed himself with a knife and threatened to harm his children's mother. A woman in a bedroom said she was in fear for her life and shot the man in the head. He died on scene.
So what does a person have to prove when arguing self-defense? I reached out to defense attorney Michael Green, who's not involved in Freeman's case.
Killing someone with a handgun, you better be able to convince some judge or jury that you were in fear of death or great bodily harm. It's not good to start it, but, you have to be careful of when you defend yourself how far you go.
Freeman has 8 convictions for various felonies and misdemeanors involving theft, firearms, and auto theft. I'm told convicted felons are required to turn over any firearms to police or a registered gun owner. So how did he get the gun? I asked HPD for more information on the weapon. Was it recovered, and who was it registered to? I haven't heard back from them.
If he's a convicted felon, he should not have had a gun in his car, which leads to the question of why? I mean, why would he have a loaded gun in his car?
Can you say anything about why he was in possession of a firearm at the time?
Well, what I can say is that he does have a documented conviction for white-collar type offense, certainly not a violent offense. As far as any weapon being involved, I have to be very careful about that at this point because, again, the facts are still coming in.
Terrifying surveillance video shows a masked intruder with a gun run up to this mid-city man about to walk in his front door. The homeowner pulls out his gun to defend himself, firing shots at the 2 intruders, quickly entering a shootout.
I guess they decided to try to come at me and come in the house, but I have a 5-month-old baby and a wife. nanny in the house, and that wasn't going to happen. There was nothing in my house that was worth dying for, but I was willing to die for my family.
The shootout happened Saturday night around 7:30. The homeowner walks to the front door grabbing for his keys. Two intruders jump the front gate. One intruder runs up to the front door. The Mid-City man throws his tea, pulls out his gun, and starts shooting.
And I don't know where I felt someone run up behind me, put something to my back, and then put a pistol to my back, and somebody else run it up.
When shots are fired, the intruders disperse. One fires back, scrambling to hop over the side fence. The other hops over the front gate and runs away. After the attack, the family filed a report with the LAPD Olympic Division.
It's a matter of time before these people are going to get caught. I think they should just pick a new career before they do end up in jail.
Before going to a trial, proving their use of force was necessary. And if prosecutors don't meet their burden of proving a crime, the court can dismiss the charge with prejudice. And that means it can never be refiled again in court.
It's June 14th. An innocent man has lost his life.
Yeah, hope that guy's all right.
Afa Alu shot in the head during a No Kings protest in Salt Lake City.
Can't believe I saw him. He was loading the AR right there.
Matt Alder told police he saw a man later identified as Arturo Gamboa holding a rifle.
I saw him load the rifle. Like, that dude was definitely not there. No.
Telling them he believed Gamboa was preparing to open fire on the protesters.
Did you just freeze for a second? Believe it, or did you go
for like a half a second? I pulled my gun, got behind the column, and I took shots at him.
It took nearly 6 months for Alder to be charged with manslaughter for Alu's death.
We went through a very sort of arduous process internally with our entire homicide team, and we tried to turn every stone we could,
weighing the evidence against Utah's self-defense laws.
Oh yeah. You want to get out? Come on, boy. Come on. Come on. What's wrong? What's wrong? Come on. Come on, you little. Ow! Ow! Ow!
The shooting death of Pat Hayes in Wasatch County following a road rage incident. The suspected shooter, Greg DeBoer.
The conduct in this case is taking Pat Hayes' life. And I don't think anyone disputes that Mr. DeBoer did that. He's admitted that.
In a statement to 2 News Investigates, County Attorney Scott Sweat wrote, "The Wasatch County Attorney's Office does not believe that there is a likelihood that the evidence can disprove beyond a reasonable doubt the assertion of self-defense in this case." In 2021, Utah State Representative Carrie Ann Lisenby sponsored House Bill 227, creating a new hearing called a justification hearing. During that, prosecutors must prove to the judge that self-defense does not apply before the case can even be brought before a jury. The justification hearing has a lower standard than during a jury trial. Representative Lisenby was not available for an on-camera interview but says the law is working. The justification hearing is functioning as intended. The law as currently written would not bar prosecution from charging either shooter with homicide. If the prosecution can meet the lower standard of evidence required under the justification hearing statute, and they believe there is a reasonable likelihood of proving the case at trial, they should charge promptly and appropriately.
The justification hearing causes the prosecutors to rethink their case, that is for sure, because they know that they will have to answer to the evidence that they have presented much sooner than a jury trial in the court hearing.
Nathan Evershed is a former prosecutor in Gill's office.
Does it cause a greater onus on the prosecutors to make sure that they can disprove self-defense? Absolutely. That part of the law, I think, has come to fruition in terms of what the prosecutors are doing. They're analyzing cases much more thoroughly for self-defense issues. And one big reason that they do that is that under our system of law, the defendant doesn't have to prove anything.
Evershed also says,
it really comes down to the evidence, and so now prosecutors are in a place where they have to really strategically and meticulously look at the evidence and see if they can get through a justification hearing in order to get to a jury trial.
Here are pictures from the video. You can see she's on the car, beating the car, and has ripped off the windshield wiper and using it as a weapon.
She says, she raised her window down that says, "Your daughter was recording me." She said, "I didn't say a thing." She waited and she paused. I had to hop on top of her car.
Eventually, Batiste Davis would lower the window and fire her gun, her only means, she said, of protecting herself and her niece in the back seat. Then she drove away. Davis was charged with 4 felonies, including unlawful use of a weapon. Her mom says she was defending herself. Daniel Ross, a criminal defense attorney, tonight is weighing in.
The victim appeared to be the aggressor. Then apparently the victim broke off the attack and moved to a different location. It comes down to the subjective decision of a prosecutor's office. Depends on the experience of the individual prosecutor, the individual case review officer. There's a volume of cases, and I'm telling you, we've got way too many shootings.
The confrontation erupted following an argument Davis had with other adults near a school bus. A student took out a phone and started recording. Davis took the phone away, and the student's mother approached Davis to go get it back. Davis said the woman jumped on her car and refused to let her drive away. According to a probable cause statement, a witness said the woman jumped on the car to avoid being hit by it.
She wanted my daughter by any means necessary. She wanted her.
At trial, Davis's attorney cited Missouri's self-defense law, which says people who are attacked have no duty to retreat. Davis claims she attempted to get away from her alleged attacker 3 times. The jury found her guilty of 2 felonies, unlawful use of a weapon and armed criminal action.
Well.